I did aspects of criminal law. Civil and criminal proceedings. Civil suits are normally private and between two parties or organizations. Criminal suits are when the criminal act puts others or society in harm's way or danger. Civil cases occur when a person, corporation, or the government, called the plaintiff, claims that someone else, the defendant, which can also be a single person, corporation, or government, has not carried out a legal deal with the plaintiff. Criminal cases are when a person is accused of a crime. If a person is charged with a federal crime, they are prosecuted by the government through the state's attorney's office. If it is a state crime, the state's attorney's office prosecutes. Some differences between civil and criminal proceedings are that with civil proceedings, you are dealing with private disputes that do not leave someone or society in danger, whereas in criminal proceedings, it is a larger issue that has the potential to put others in danger. There are far more differences than there are similarities between civil and criminal proceedings. In both proceedings, a judge and a jury hear your case. Procedural and substantive due process. Procedural due process is where there are no fair procedures controlling the state conduct, which is an affirmation by the 14th Amendment. Substantive due process is a right by the 14th Amendment in the Constitution where state conduct is so brutal, demeaning, and harmful that it is a shock to the conscience. They both originate from the 5th and 14th Amendments of the U.S. Constitution and are two different views on the due process law. In procedural due process, it protects a person's fundamental rights by making sure the government follows rules and everyone is given a fair trial and chance. However, substantive due process is where it keeps the government from going over the limits that they set for themselves. So in procedural due process, it protects citizens from the government and everyone is treated equally and fairly, and in substantive due process, it keeps the government from stepping over boundaries that were set by themselves. English common law. Common law was the first part of the criminal law that was established. Criminal law in the United States has come from the common law of England. In the Middle Ages, kings took control of England, and they had royal judges that judged both civil and criminal trials. They created laws and began to form a foundation, and the judges started to become familiar with them to better their judgments and rulings. By the 1600s in England, they had a set of rules that they put out. This set of rules became common law crimes, which are the crimes that are created by the judges. After the start of the American Revolution, people became upset because we had English common law crimes for Americans but no American laws for Americans. Lawyers in America knew how much time and effort was put in by the English and royal judges to form these laws. After all, it was a span of over 200 years. So English common law became statutory law. In England, it was the English judges who made the basis for the laws and determined if the laws were broken as well, but the population at the time was not to the point where they couldn't handle both responsibilities. Constitutional case and statutory laws. Statutory laws are laws that were the outcome after the English common laws was converted. Just about all criminal laws that are enforced today are statutory laws. They are just enacted by legislative bodies. Examples of statutory law are the speed limits placed on roads and the legal drinking age. The police are the ones to enforce and deliver punishment of these laws when they are being violated. Statutory laws relate to the criminal justice system because they are laws that are in place to help keep society safe, and when people do not follow or abide by them, a punishment is handed down. Constitutional law is the body of law that derives from our nation's written constitution that provides the duties and powers of the government and states the rights and duties of the people. The constitutional law implements the U.S. Constitution. It handles the relationship between the states and federal government, the branches of the government, and the rights of the people in relation to both the state and federal government. Constitutional law relates to the criminal justice system because it is basically the basis in what formed the criminal justice system in the first place. Case law is laws that are formed and established from the outcome of other cases. The neat thing about case law is that they are always developing and changing, and new laws are being formed from previous decisions. Legal precedents are cases and issues that are decided by the court and are used for the future to answer similar questions. Stare decisis is when the courts are handling a case that has similar facts and issues to a previous case. It is required that when judging the case, they have to adhere to previously decided cases, especially when it is a lower court. Case law relates most closely to the criminal justice system because cases that are decided in the criminal justice system are used for decisions and to solve issues in further cases, and it helps better and improve the courts in future cases like it. Ex post facto law. An ex post facto law is an after-the-fact law. It is a law that punishes someone for an act that they committed that was not illegal at the time, but now it is. The ex post facto law only applies to criminal law, but not to civil law. Ex post facto clauses. In the clause of the ex post facto law, it prohibits the following: laws that are made retroactive so as to make conduct before the enactment of the law a criminal violation. Laws that aggravate a crime retroactively, such as making a misdemeanor a felony as of a date 6 months prior before the enactment of the law. Laws that increase the punishment for a crime retroactively, and laws that alter the legal rules of evidence and permit convictions on less or different evidence than the law required at the time of the commission of the offense. Burden of proof in criminal proceedings. The burden of proof in a criminal case is the responsibility of the prosecution to convince the judge and jury that their facts and evidence are correct and the defendant is guilty. So the burden of convicting the defendant is on the prosecution. In the United States, anyone who has been accused of a criminal act has the right for their case to be presented in front of a judge and jury, and they have a right to a fair trial and are innocent until proven guilty, and that is where the courts and the burden of proof come in. When proving beyond a reasonable doubt, the judge and jury must be certain the defendant is guilty in every aspect and element of the crime they committed, in order for the defendant to be convicted and sentenced. The prosecution must also prove actus reus, which translates to guilty act and is the mere act of a crime, and also proves mens rea, which translates to guilty mind and is the state of mind of the person at the time of the crime and the intent to commit the crime. Elements of crimes. There are certain legal and essential elements of a crime. The prosecution has to prove these elements to convict the defendant. These elements are the act element, which is the failure to act, the mental element, which is the state of mind that is required for the crime, the harm element, which is the wrong done, which can be property damage or killing. Not all of the crimes have to have a bad end result, and finally, the cause element, which is the harm done, was the natural and probable result of the wrongful act. In order for a crime to be committed, 3 things have to happen in order for punishment. The first is actus reus, which is the guilty act of a crime. The second is mens rea, which is a guilty mind, and a person is aware that what they are doing is a criminal act. The third is the combination of actus reus and mens rea together, because without one or the other, there is no crime. Legal defenses in criminal law. The insanity defense is the most debated and one that has received the most attention. Insanity tests are conducted to determine the degree of insanity, mental defect, or the mental disease. Sometimes the defendant and the defense is put in a place where it has no other choice but to claim the insanity defense because the evidence that is being used against them is good and strong. The insanity defense is most oftentimes proved by preponderance of the evidence. According to the book, only about 2% of the defendants use the insanity defense. The defense of diminished capacity, which is where the defendant may have certain emotional or mental conditions and didn't meet or have required mens rea before being convicted. The defendant may not have had a mental condition at the time he or she committed the crime, but at the time of trial, their mental condition prevented them from gathering an intent that is required to be convicted. The diminished capacity defense is not technically a defense because it's not something they can claim, since it has to do with mental and emotional being. Self-defense and the defense of another person. Self-defense, defined by the book, is the elements to evaluate whether an act of force for self-defense is justified include the unlawfulness of the other's actions, the necessity to defend oneself immediately, and the reasonableness of the act of self-defense under the circumstances. There are certain points that decide the lawfulness of force for the defense of others in self-defense. They are unlawfulness, necessity, and reasonableness. There is so much that is taken into account when determining when force is reasonable and when it is not, such as the age and size of the person, strength, level of aggression, if an object or weapon was used. With self-defense, it is usually a good defense because most of the time they can prove why they were trying to protect themselves or another. Affirmative defenses are when the defendant admits to performing a criminal act but claims that they were forced to do it or persuaded. Basically, they claim they committed the act but have a good reason as to why they did. Immunity as a defense is when a person is exempt from being prosecuted because the basis of their claim to immunity may come from the U.S. Constitution, a statute, or an international agreement. The defendant may get diplomatic, legislative, witness, or transactional immunity. Mistake or ignorance as a fact defense is a common law rule that can either be an honest mistake or ignorance of a fact, and can be used as a defense if it neutralizes the existence of a state of mind that would be essential to the crime committed. Intoxication or drug condition as a defense is a defense that more often than not does not work out in the defendant's favor. An example would be someone robbed a gas station and they claimed that they were high on drugs and was therefore not in their right mind when the crime happened. The defense of duress, coercion, and compulsion can be a valid defense if they can prove that their behavior was because of duress, coercion, or compulsion, but only under some circumstances. Duress is when the person was forced to commit a criminal act, and coercion is when someone forces another person to commit a crime. Alibi can be used as a criminal defense, which is when the defendant states and shows that they could have not physically committed any crime. It could be that they were in a different location or even different state when the crime happened, and have other people that they were with testify to prove that it is indeed correct. Alibis are closely investigated because of the fact that everyone could be lying and it could be all be a setup. And these are my references.